Due Process, winner of 21 Regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2012 Mid-Atlantic Emmys for Outstanding Interview Special and Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
Lincoln suspended it during the Civil War in the name of preserving the Union. And his move on habeas corpus is still debated and decried a century and a half later. But in the years since 9/11, the writ of habeas corpus has again fallen on hard times. Detentions, military tribunals, Guantanamo. Do they violate the Constitution, put civil liberties at serious risk? Habeas and the War on Terror, with two professors who wrote the book, on this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy.
The Constitution says it shall not be suspended unless when in case of rebellion or invasion, the public safety may require it. Habeas corpus, a legal phrase familiar to even non-lawyers, especially since the attacks of 9/11 and the so-called War on Terror. I'm Sandra King.
And I'm Raymond Brown. And with Guantanamo detentions for more than a decade, with military tribunals gearing up again, what better time to talk about the great writ, habeas corpus, and what better guests than two authors on the subject, law professors from Seton Hall, both of them counsel to Guantanamo detainees.
Jonathan Hafetz, a former lead attorney with both the Brennan Center and the ACLU, is the author of Habeas Corpus After 9/11, Confronting America's New Global Detention System. He and Mark Denbeaux, director of the Law School Center for Policy and Research, are also co-editors of the Guantanamo Lawyers, Inside a Prison, Outside the Law.
Welcome to both of you. Jonathan, let me start with you and see if we can set up a framework for the conversation. What you've described in your very well-written and lucid book about 9/11 and habeas is a zone outside the rule of law. Spatially, Guantanamo, Bagramo, we controlled it, black sites, and also conceptually, torture, other kinds of activities that would seem to violate the rule of law. And this in violation of habeas as well as the law of armed conflict. Is there no theoretical justification on the other side other than the executive's power to conduct military campaigns? Is there nothing on the other side that is an argument that requires legal analysis and careful refutation that would seem to have the resonance of the Great Writ and the law of war?
I don't think there's really much on the other side to be said. If you're a nation that's going to abide by the rule of law, power has to be constrained, and executive power, and particularly executive detention, needs to be constrained by legal rules and a judicial check. And so what we have with the Guantanamo detentions is, in a sense, a throwback to centuries ago. If you can picture the king really locking people in the tower with no charges, no access to a lawyer, no trial, and being subjected to brutal conditions, habeas corpus emerged from those circumstances to provide some kind of check and say, look, maybe the king can detain you, but he has to go before a judge.
So, Jonathan, for the lay viewer who is sitting there saying, well, what exactly does that mean? What exactly does habeas corpus mean?
Well, habeas corpus comes from the Latin, meaning you have to have the body, and it essentially means that initially it meant that the prisoner had to be produced in the court, but what it's come to mean is that if a person is arrested or detained by government authorities, that the government has to provide a legal cause, a basis before a judge. Why are we holding this person? What's the rationale? And it has to be subjected to court review. It's that check by a judge, an independent judge on detention.
And that's the theory. And yet, Mark, we saw over several years following 9/11 the growth of not just Guantanamo, but the black sites, what my old friend Chris Hedges calls the emerging gulag. And what happened? What went wrong? Why didn't habeas just kick right in instead of waiting until 2008 in a court decision which may not have had so much impact as we'd like?
Well, I think Jonathan's point is that there really is no good legal argument to justify the absence of habeas corpus. I think the answer is, however, there is an explanation for why they did it. And that was just fear and politics. I don't think anybody could, in a straightforward way, can say there was a legal doctrine that existed to justify not only the gulag you referred to, not only Guantanamo, but locking up thousands of people as material witnesses, deportations of people. It's just a cluster of terrible things that happened, and it's a result of panic and fear. And
So
America does that.
Did America just say, did Americans say, take our civil liberties, but keep us safe?
No, I think they never said take our civil liberties. They always claim that this is an urgent time and we have to enforce the rule of law, even when they're not. I mean, it's not as if we haven't had in every generation events like this. This isn't the first time we've ignored the rule of law. Whether you want to talk about the Japanese internments during World War II, if you want to talk about the Red Scares after World War I, if you want to talk about the syndicalists and the anarchists, and if you can go all the way back to the Alien and Sedition Acts, it's simply something that when we panic, our system holds up very well in the mainstream circumstances. And when America panics and gets afraid, the system isn't strong enough to withstand that pressure.
Getting back to Guantanamo and habeas, there is, in a sense, two areas of concern and discussion. One are the black sites. I guess we shouldn't use that phrase without defining them, but black sites and Bagram, while it was under United States control, the penal section of it, and Guantanamo, which seems to have been the focus of special attention, and some arguments that seem to surprise, rulings that surprise the Bush administration. Can we look at them all together, or do we have to look at Guantanamo separately if we're analyzing the impact of habeas on the so-called war on terror?
I mean, I think you have to view them together as part of the same essential system after 9/11, which was to create prisons outside the law, and they were outside the country too, which was one of the rationales. And so Guantanamo was the most visible example. It's the one that's garnered the most attention. It was public to the extent you knew it existed. And at the other end of the spectrum, you had the secret CIA black sites, which were intended to be, no one knew that they existed. They were secret jails, but they were linked by the idea that these were essentially prisons that were outside of any framework, any domestic laws and any international laws.
Let me push this argument a little bit, because the Supreme Court did ultimately say that there was so much control effectively over Guantanamo that habeas had to be considered, as opposed to, for example, black sites, which are sites that we know exist but we can't identify, and the idea of rendition, which means we send detainees to other nations where torture is more likely to happen. Aren't those conceptually different at all, or do you think at the end of the day we'll find that habeas either applies or doesn't apply equally across that spectrum?
Yeah, I mean, I think that the court drew a line, although a soft line, in saying Guantanamo was sufficiently like the United States. It was under sufficient control. It was close enough that the habeas rights and judicial process would extend there. But it did not say that habeas corpus applies everywhere. What it did do was it left the door open to say maybe yes, maybe no. And to that extent, it was a rejection of the government's view that simply because a prison was outside the U.S. and we weren't holding citizens, there was no possibility of review. At the same time, the court said, there might not be review, and it left it open to a kind of case-by-case, determination. So it's always possible, but at the same time, we still can have and do have with places like Bagram prisons outside the law.
I think it's a mistake for us to lump them together, even though you can explain why there is this worldwide system. I think one reason it's a mistake is that things have importance that transcend their actual legal circumstance. I don't think we lose a lot if we try to compare the dark sites, which are a special kind of horror, rendition, whether it's Bagram, whether it's targeted assassinations. We can put together all the bad things that are happening, but Guantanamo is probably the best vehicle for discussing what our legal doctrines should be under pressure, because the rest of them are just as horrible, but they're not as defined. They don't have the same strength and force to them that allow us to analyze what it is our country really is doing.
And Mark, you became an important part of that discussion when you and a group of law students put together quite an incredible report that said the government's rationale that these are the worst of the worst, and therefore we really need to do whatever is necessary, that underpinning was in fact totally incorrect.
Now, that was one of the remarkable experiences. First, it tells you a lot about the value of law scholarship, because I've written a bunch of law review articles that have fallen like a stone in the ocean without a ripple. We do this one report, and all we do is look at the government's own data and puzzle through it.
And next thing you knew, you were in front of Congress.
Well, that's correct, because there were some people in Congress who were distressed to find out that the one thing that the government claimed about Guantanamo that was totally false was that they were the worst of the worst, when in fact they're the least of perhaps the best of the world. And you know, the odd part about it is that a couple years ago we discovered a memo written by Rumsfeld to the chair of the Joint Chiefs of Staff in 2003, complaining that Guantanamo was populated with nothing but low-level people. So they knew all along.
And some of them, would you say, entirely innocent, should never have been picked up, were picked up because perhaps somebody took a bribe and handed them in?
Well, I think it's undisputable that most of them fall in that category. I mean, after all,
most of them.
The government has released unilaterally, without any court order, without anything, 600 people. And the best the government can claim is that there's 30 or 40 of them who have misbehaved afterwards. And I use misbehave afterwards because it'll turn out being Russians getting arrested in Russia, Moroccans getting arrested in Morocco are somehow proof that these people misbehaved. And the fact of the matter is—
not just misbehaved, but a threat to United States security.
There's no evidence of any person up until perhaps some references to things that took place in Libya that we don't even know are true, but there's no reference anywhere to any person who's left Guantanamo ever attacking the United States interests, or United States forces. And think of that. 550 people have been released, and the government doesn't even question the fact that they have not returned to their normal life. Some are doctors, some are politicians.
Jonathan, let me take you somewhat outside of what you may profess as your area of expertise, but it's too tempting to resist. It's not as though even moderate voices— I remember Justice O'Connor saying right after 9/11, we're going to have to make some serious choices about civil liberties. So it's not as though we were unaware of the dilemma, and yet we're a nation that prides ourselves on an exceptionalist myth about our commitment to the rule of law above other nations. How then, 10 years after the last successful attack on the United States proper, does the United States remain unconcerned, apparently as a body politic, about violations of process and habeas where people who are known to be not a threat and not culpable are detained?
Well, I think one of the problems is the extent to which what was deemed as exceptional and understood to be perhaps temporary to meet a threat has become institutionalized and permanent. I mean, with Guantanamo, we've grown more used to the idea of indefinite detention, and it's become a more permanent feature of the legal landscape. It's really a question of how far it's going to extend, and sort of beyond Guantanamo. But that's one of the challenging things about terrorism and the way the United States has approached it. It doesn't appear to be one where the pendulum will swing back so quickly to peacetime restoration of civil liberties. I mean, I think it's swung back a little bit. They're not the same policies are being pursued. The U.S. Isn't doing the same, engaging the same interrogation techniques. There's greater legal review and process, but it hasn't gone back to where it was pre 9/11. And so I think a lot of what's happened has become permanent.
And isn't it also about who's being detained? And once you've got a group that can be seen as the other, it's much easier to do this kind of thing without public outrage. You may be outraged, but do you have any illusion that the American public is outraged by Guantanamo or anything else that's been done in the name of our security?
Look, let me answer that in one way. Jonathan thinks that we've come to accept preventive detention. I think we've forgotten about what's happening. I don't think the American people are accepting preventive detention in Guantanamo. I think Guantanamo has just disappeared from the American consciousness. And I think if you asked a certain level of fairly informed Americans whether Guantanamo was a good idea or a bad idea, whether it represented what we believed in or what we didn't, I think an awful lot of Americans would say that was a mistake.
Let me gently challenge that by asking you a different version of the question I asked Jonathan. A couple of years ago, there was a decision made to take Khalid Sheikh Mohammed, publicly identified as the mastermind of 9/11, try him in the civilian court system in New York with some bipartisan support. Tremendous outcry from the population of New York and essentially a backing away from that. So a miscalculation on the part of the leadership of the United States, which was trying to think about moving out of the military commission system for these defendants, and a real visceral response from a part of the population you might think of as sensitive to some of the civil liberties issues.
Well, I think, okay, and my first answer to that is I think it's one of the great civil liberties tragedies of this period that New York City got so panicked and so afraid. I've never believed there was a city in the world braver than the New Yorkers in New York. And here they were, the group of people having the opportunity to prosecute and convict the people who killed everybody in the World Trade Center tower, and they said it's too scary, it's too expensive, do it somewhere else. And by doing that, then we ended up in this really ugly situation with these military commissions in Guantanamo, which people are forgetting about. And your question is, though, how did the political figures miscalculate that, right?
Yes.
I think the political figures,
especially in light of your saying that you felt people were not alert to these issues, and if we talked about it, they would. But here, when confronted with moving out of the military commission system into the civilian courts, they recoiled.
okay, I was not trying to get away from the fact that fear is still the dominant force that damages our legal system every time it happens. And I think fear explains that. But my target for the group of people who I would think would be likely to say no more Guantanamos would not be liberal Democrats, wouldn't necessarily be Democrats, it could be moderate Republicans. I think a whole lot of thoughtful people would say we don't want to be in this situation again. It didn't work, it wasn't a good idea, it damaged us. And I just think that the New York response reflects how fear can be manipulated to break our system down and wound us. And I think that's what happened there.
Let me go back to Chris Hedges for a minute, who's got a recent piece called "What is happening to Muslims will happen to the rest of us." Jonathan, is that an overstatement of where we are?
Well, I think it certainly highlights a risk. I mean, we've one of the lessons from the past is the extent to which policies developed in times of fear, repressive policies that limit civil liberties, start out by targeting the least powerful, non-citizens, people who can't vote, don't have the same power, and they inevitably end up migrating and affecting citizens as well. In fact, you can trace a lot of what went on during the Cold War and the McCarthy era, which certainly affected U.S. citizens, to policies that were initially carried out against non-citizens in terms of deporting radical aliens and things like that. And so there's always a risk that what's done to minority groups will end up affecting everyone. And so it's a reason to be vigilant about civil liberties. And by the same token, I would add that if policies are done even-handedly and are not and don't just target non-citizens, For example, the military commissions, which only can try non-citizens. But if they're done even-handedly and try citizens, those policies will not be as bad, because so you need to have, that's why it's important, I think for things to be done even-handedly.
All right, Sandy and I have sort of developed a tradition of asking people at the end of our show to look into the future, but we wanted to start with you a little bit earlier, because so much of this, and we sort of had a subtle debate about whether this book that's so well written ends on an optimistic note or not. Sandy thinks it does.
I think it does.
I think it's a so carefully guarded optimism that I'm not sure. But at the end of the day, are we 10 years from now? Do you see things that suggest that Guantanamo as a specific problem and also as a symbol of a larger willingness to move into the zone of lawlessness are likely to come back to a more rooted tradition of habeas, or are we stuck where we are and likely to be for the foreseeable future?
Well, I think the years demonstrated the value and the importance of habeas corpus, but at the same time, what happened after 9/11 demonstrated the vulnerabilities of habeas corpus in terms of the length of time it took for these legal victories to be won and for detainees to get their day in court, and then what's happened.
So your confidence is rooted primarily in the judiciary's willingness at the Supreme Court level to say no, sort of.
Sort of.
To say no sort of, and judges, I think, generally no sort of, but I think that, one of to me, a big lesson after 9/11 is that what the Bush administration did was make incredible assertions of executive power, and they moved the goalposts so far in terms of what the normal is that they've gotten moved back some, but it's very difficult to recover and for things to kind of go back to where they were when they've been moved so far. So there have been restraints, and the system does restrain, but there are permanent effects, and things become institutionalized.
Are you a Hafetz optimist? I'm sorry, Mark. Are you a Hafetz optimist, or?
I don't know where it fits on the optimism continuum, because I'm going to say this. I believe America goes through episodes where we make terrible mistakes and they damage us and wound us, and the only question is, what lessons do we learn from it? I think to some extent we're missing the point if we're trying to figure out where the law of habeas will be 25 years from now on the next crisis that happens. I mean, you could sit there and talk about deporting aliens during the radical syndicalism period. You could talk about what happened during McCarthyism and taking people's jobs away without due process. I think we keep finding areas where we fall down, and I think the real lesson I'm optimistic about is after we fall down, after we fail, and after we do these bad things, we at least get up and say, we won't do that again. It doesn't mean we won't do something else bad again, because we're human beings and we're a system full of flaws, and the one lesson we have to learn is, and every time we have to learn it, is there's no system that you can put in place that will protect us from the harm we can do to each other when we are facing the fears and the anxieties that take over us at different times.
But I wonder, unlike World War II and the detention of Japanese citizens and non-citizens, we are continually told, and perhaps it is true, that this is a crisis that isn't going to end, that we've got this war on terror, as it's been called, is nonstop. There is no end to it. So where does that leave us, Jonathan, in terms of how we approach civil liberties and how far we're willing to go in the name of protection?
And you've got 30 seconds to tell us.
Well, that's a key issue, is that this war seems to be different. There is no divide between war and peace, and it has implications not just in the detention context and habeas corpus, but for a range of issues, the use of targeted killing, predator drone strikes, where the idea of a kind of permanent global war has ramifications that I don't think we fully have internalized yet.
Mark, does the war on terror go on forever, as Sandy suggests?
Some war goes on forever. I don't know if you want to call it the war on terror. I mean, Obama never refers to the global war on terror. We're talking about fear and national security, but the war on racism has never gone away. It seems to me we're always at war with someone, and I think that's the scariest thing of all.
What I wish could go on forever is this conversation. Very fruitful. I hope you'll come back. But that's it for this edition of Due Process. We'll be back next week and every week with more on law and justice. Our thanks to Jonathan Hafetz and Mark Denbeaux. For Sandy and all of us here, I'm Raymond Brown. Thanks for watching.
See you.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.